Hi everybody, welcome back to Law Hero. Congratulations if you've passed some of your FE1s. I love getting all your messages saying thank you for the concise notes, and so I never say I guarantee that you'll pass, but I'm pretty sure that if you buy my notes you'll pass. So I'm after just completing the ebook for EU law. You'll see it up on my website. I'm very proud of it. The more familiar you are with this bad boy, the better. I actually have memories of bringing this with me when I was a swim teacher in Germany. I would bring this always on the bus. Now I've actually made a list why people fail EU law exam, and this can also be applied to other FE1s. So obviously the biggest reason is not answering 5. The next one is not knowing enough legislation and cases, and in my opinion in the EU law exam this is unforgivable when you are allowed to bring in the legislation. The cases can be forgiven, but we'll say if you only know one case or two cases on every topic, he's not going to like that. And highlight cases and relevant legislation, and actually what this does is psychologically it primes him to think that you know what you're talking about. And the other thing he doesn't like is people who don't write legibly. Now that's the only FE1 examiner I've seen to point that out, but it's actually a fairly legitimate concern. I mean, you may be the best FE1 candidate in the world, but if you don't set out in a legible manner what the answer is, you're going to get their back up. So I advise to avoid the case law question. Now this is totally up to you, but if you're thinking in a logical and rational manner about the time you have to study, why would you take a lucky dip at 8 cases and what you study might not even come up? Because everything is in the legislation, I have, so we'll say like if you're talking about sources of EU law, I have highlighted in yellow every single either TEU or TFEU article, and if you don't know the difference between those, you ain't doing the exam, honey. If you want to get a really high mark in the FE1, and this is across the board in all the subjects, you have to bring in your own opinion, which is insightful, and you have to bring up some articles and academic commentary. Obviously, if you have all the time in the world, you can read around the topics, but that's not what this channel is based on. This channel is based on people who are time pressured, working in a job, and want to get the basic facts and pass the exam and are not going for high grades. All people don't pay attention when there's a choice of question. Look out for small words like and or. So the other thing he doesn't like is when you just like write verbatim on a directive or a regulation. So for example, on the Citizens' Right Directive, which is copied in full into your Blackstones, if he asks you questions about citizens' rights and you start just writing stuff, as in lifting the text from the open book, you're going to fail the question because you're not answering the question. And this is the trap with open book exams, and you'll find this on the PPC1 and the PPC2 as well. People are like, oh my god, it's so easy because I got to bring in my book into the exam. No, oh my god, no, it's way harder. When you need to bring a book into the exam, you're being marked harder because the examiner's like, well, you have the law in front of you. So if you haven't done the work to find it and understand what it's about, I'm going to fail you, and clients are going to want to like hear what you have to say. So you can't do this to a client and you can't do it in an exam. I think it makes sense, you know, because this is a professional exam, by the way. It's an FE. It's the first examination into the profession. You know, don't get it twisted. Okay, so I'm going to cut the general jibber jabber about EU law, and bear in mind, please apply that jibber jabber to all other subjects. And now we're going to get down to the nitty gritty, which is the March 2019 EU law paper. Now all this stuff is available on the Law Society. I'm just summarising it because I think it's actually useful to go through it and give my 2 and 4 pence. So I'm going to cut to the chase. Okay, so the first question was a nice question because it settles people down. It's a question about the institutions of the EU, settle the nerves. I would advise to do that one first. I think he's trying to be nice by putting it on. However, you need to read it carefully because what he says is outline the roles of the various EU institutions in EU lawmaking and assess how these roles were changed by Lisbon. That's the hard bit because you can be like, the Commission, the guardian of the treaties, Parliament, direct representation, the Council of the EU is the member state representatives, and well done. But you didn't answer the question. You didn't tell me how their roles have changed since Lisbon, and that requires a bit more work. So question 2 was a question on the direct effect of directives. And how would you know this? So it's quite a long problem question. It's about not including substances in paint stripper. It's a made up directive. As you know, directives are transposed into the national legislation by regs, and they don't have to be word for word. There can be some member state deviation on directives depending on that's why they're directives, depending on what the national situation is already in relation to that topic. So it allows the Irish legislator to provide the quantity of this chemical, as in what quantity of this chemical is not allowed in the paint stripper. Whereas the directive has said those substances are not allowed to be in the paint stripper at all. So this is kind of a wide gap between what the directive intended and what the Irish legislator actually did. So question 3 is actually quite classic. It's a reference to Article 263, Procedure and the Effect of Judicial Protection. It's a nice essay. And he also quotes UPAV Council A.G. Jacobs' quote about the being individually concerned. So here you would look at locus standi and you go through the developments here and you talk about Ploughman and Greenpeace and Cordonu, and I've done all of that in my notes. That was a nice essay. Question 4 relates to the freedom of movement of goods. So here you have someone selling bread, and what happens is then they are told that they're not allowed to use certain descriptive words like traditional, farmhouse and artisan in their products. They've been reserved for small scale producers only. So yeah, the key issue is that the state can justify the imposition of this regulation. So is it for consumer protection or the protection of commercial rights? So in my notes, you need to understand what measures having equivalent effect to that of customs duties and quantitative restrictions actually mean. So if it's quantitative, which is not a payment of money, restrictions on imports or measures having equivalent effect, that's MEQR, and that would be, for an example, an overt quota. And what you do is you look to the effect of the quota and not the aim of the quota. And then exceptions on the prohibition are Article 36. So this is not a monetary restriction. So they export 25,000 loaves of their farmhouse Irish soda bread to Germany every week. And here it says, any bread manufacturer who produces more than 15,000 loaves per week, they are no longer allowed to use those descriptive words. So that is, they're 10,000 loaves above the quantity. So it's a measure equivalent to a quantitative restriction. So in question 5, an actress is experiencing some, alleged discrimination when she goes for a job in Scotland. And we're told that the Scottish Board of Performing Arts is state funded, and this would automatically lead us to start writing crazy about Article 45 TFU and whether the employer is state funded or not. It doesn't really make a big difference, because actually Article 45 can apply to private employers as well. So what you would do is go to my notes, and first of all you need to establish that she's a worker. Then you'd have to look at who her employer is. So I have that done as well. And you have to remember as well that there are exceptions to the rule. So if there's an overriding requirement in the public interest, applied in a non-discriminatory manner, and there's also a public service exemption, but that doesn't really apply here. Then what you would do is look to the secondary legislation which applies to workers. So for example, as I said before, there is a regulation on free movement of workers, and that is in your Blackstones. And that looks for equal treatment in remuneration, social and tax advantages, and trade union membership. So to my mind, I think she would be better off using that regulation for her case. Question 6 was a really lovely question. It's one I definitely would have done. It was a critical assessment on the status of human rights in the EU legal order. Refer to CJEU case law and to other EU primary law like the Charter of Fundamental Rights of the EU, which is actually in your Blackstones. You can also use Caddy. So Caddy was from Saudi Arabia, and he was living in Sweden. And what he actually did was set up a charity for Somalian refugees. And when he became connected, well, allegedly connected with Al-Qaeda and Osama bin Laden, the Swedish authorities just froze all his bank accounts, and he took a case to the CJEU arguing that his human rights had been breached and that he wasn't given a fair. Okay, so the last question is on mergers. In my notes I talk about the substantive test for merger control, and how about the significant impediment of effective competition, which is the SEEK test, which is different to dominance under Article 102, because it's more merger orientated, and what it does is it upholds the established good practice in case law as regards to dominance, but at the same time it takes a more effects-based approach when assessing mergers, which is important because when two companies come together, they may not be dominant before the merger, it's afterwards, which is important. So they couldn't apply the dominance test to how they are right now, so they needed a creative solution. So, you know, all in all, my notes are, if you had my notes and you did the March 2019 paper, you would have been extremely well covered. I traditionally only cover 8 topics in every one of my ebooks, and I can always guarantee you that you'll pass the exam on those 8 topics. So thank you very much for watching. Next video is criminal law, which I'm going to film straight after this one, so stay tuned.